Hello and welcome to the AIFC Court and IAC webinar series 2020, New Opportunities During and Post-COVID-19. Today we have webinar 11 in our 2020 series. The topic is Construction Contracts and Adjudication. Today's speaker is Justice Sir Rupert Jackson from the AIFC Court, and Sir Rupert is a leading authority on many areas of law, but specifically on matters of construction law. We have 1 hour for today's webinar as usual. Sir Rupert will give his presentation and we will then open the floor for questions. If I may ask you as usual, please to type your questions in the Q&A option shown at the bottom or top of your screens, and Sir Rupert will answer the questions at the end of his presentation. Thank you very much, and I hand over to Justice Sir Rupert Jackson.
Thank you very much, Chris. May I begin, ladies and gentlemen, by congratulating the registrar. Both the court and the arbitration centre have remained fully operational throughout the lockdown. In addition to arbitrations and court proceedings, there is also a great deal of mediation work being done here. There have been, I think in all, some 83 mediations conducted through the AIFC Arbitration Centre. The parties come from many different jurisdictions. Remote working is not a problem in the AIFC Court or the AIFC Arbitration Centre. As the registrar has told you, today's webinar is part of a series which we are running during the lockdown period. This is indeed the second webinar this week and the 11th webinar in the present series. My title, as you can see from my paper, is Construction Contracts and Adjudication. Now, of course, Mr. Chairman, construction law is a subset of the law of contract. The general principles of construction law apply to the general principles of contract law apply to construction contracts in the same way that they apply to all other contracts. But as I set out in paragraph 2.1 of my paper, the nature of construction contracts and the exigencies of construction projects means that a group of special rules and procedures has evolved concerning these disputes. Indeed, because it is a specialist field, some jurisdictions have established specialist courts to deal with construction disputes. And as you can see from paragraph 2.2, in England and Wales, that specialist court is the Technology and Construction Court, known to all as the TCC. Now, building projects generate disputes of high value and great complexity. These usually arise out of standard form contracts which are used internationally. For example, the FEDIC conditions, which all of you will be familiar with, are used widely in civil law jurisdictions and in common law jurisdictions. So also it is the Delay and Disruption Protocol. This very valuable protocol was developed by the Society of Construction Law, a body which now exists in many jurisdictions across the world. And I hope that if there isn't a branch in Kazakhstan yet, there soon will be. Anyway, the Society of Construction Law has published a Delay and Disruption Protocol. It's now in its second edition. It's frequently used in civil and common law jurisdictions. At the moment, these construction disputes almost always go to arbitration, both in civil law countries and in common law countries. So arbitrators around the world are grappling with the same problems which arise out of the FEDIC conditions and the protocol, but they are doing so largely in ignorance of what their colleagues are doing. One of the great benefits of arbitration for the parties is confidentiality. One of the great drawbacks for the wider community is that arbitrators and parties don't know what is being decided in other cases raising similar points. And so, Mr. Chairman, as I say in paragraph 2.5, the new international commercial courts, which are popping up all over the world, and this court here in Astana is just one of them. These new international commercial courts provide a very attractive forum for such cases because the judgments are given in public, they are reportable, and there are specialist judges who know their way around construction law in many of these courts. By way of example, Sir Vivian Ramsey sits in the Singapore International Commercial Court. He is a former head of the Technology and Construction Court in London. Likewise, this court, the AIFC Court, can also offer construction expertise. Like Sir Vivian, I too am a former head of the TCC in London, in the UK. It would be very helpful for the construction industry and also for building owners if a body of case law on construction disputes were to emerge from these international commercial courts. Of course, we have national law reports. As I say in my paragraph 2.6, the building law reports published by Atkin Chambers in London are a very good example. But what we really need is a set of reports of construction cases which arise out of international projects and which have been decided in international commercial courts. Now, will this give rise to any coherent body of law? As I say in paragraph 2.7 of my paper, Chief Justice Menon of Singapore has speculated that a common lex mercatoria may well emerge from the international construction court, from the international commercial courts. Likewise, I would suggest a general lex constructionis may emerge from the decisions of the new breed of international commercial courts. So those are a few general observations which I make about construction disputes and dispute resolution. Let me now turn specifically to the topic of adjudication. As explained in paragraph 3.1 of my paper, in the latter years of the last century, there was rising concern in the UK about the cost and the delay of construction litigation. Cases used to take years to come to trial, and then some of the complex cases would spend many weeks in trial. I well remember that, having participated as counsel in such cases during the 1980s and 1990s. The problem was that many contractors and subcontractors were in dire straits. Main contractors or employers were failing to pass money down the line. Instead, they were raising dubious counterclaims. These had to be investigated. That took a great deal of time. And while the contractors or subcontractors were waiting, they may well go under. So great was the concern that the government set up an inquiry. This was a groundbreaking inquiry headed by Sir Michael Latham. It was set up in 1993 and it produced a report in July 1994, which is popularly known as the Latham Report. This report recommended that there should be special rules in construction contracts which would secure prompt payment of monies which were due and the prompt resolution of disputes arising under these contracts. So here we have a set of special rules being proposed, not to be grafted onto the law of contract in general, but to be grafted onto the law concerning construction contracts in particular. Those recommendations were implemented, sorry, I was looking at a message, it flashed up on the screen suddenly. Those recommendations were implemented in England by a statute with the long and unwieldy name, the Housing Grants, Construction and Regeneration Act 1996. That act came into force in 1998. The Act requires every construction contract to provide for a payment regime and an adjudication regime which complied with the requirements of the Act. Now, the payment regime begins by banning pay when paid clauses. In other words, clauses which say that the main contractor won't pay a subcontractor until he has had money from the employer, or a subcontractor won't pay a subcontractor until he has been paid by the main contractor. It is particularly important for the smaller businesses, some way down the contractual chain, that they should obtain prompt payment rather than wait for money to pass all the way down the line. Secondly, in order to secure prompt payment, the legislation said that when a contractor or a subcontractor reaches the stage of an interim payment being due, he serves a notice, and then the party liable to pay must do so promptly unless it serves a withholding notice explaining with reasons why it is not claiming the sum which has been sought by the contractor or subcontractor. So that is one aspect of the legislation introduced in the 1990s. The second aspect of that legislation was to introduce an adjudication regime which would achieve the prompt resolution of disputes, avoiding the long and turgid process of construction litigation, courts, or some administrative body. The essence of adjudication is that it is swift, it is temporally binding, and it can be reopened if the adjudicator has gone wrong. I set out in my paragraph 3.4 a very brief description of adjudication. An adjudicator is appointed to investigate a construction dispute swiftly and relatively informally. The adjudicator reaches a decision in a short period of time, which typically is 28 days. That decision is temporally binding. In other words, the parties must comply with it, whether they like it or not. But if either party is dissatisfied with the decision, then it can embark upon the full legal process. It can have either an arbitration, if there's an arbitration clause, or failing that, it can litigate in the courts. But the adjudicator's decision has, in the meantime, been complied with. So if a contractor seeks money which is due to him, the employer refuses to pay and serves a withholding notice, the contractor can bring an adjudication. Within 28 days, the adjudicator will reach a decision. The adjudicator may order £50,000 or whatever, or $50,000 to be paid to the contractor. The employer must pay that sum. Thereafter, if the employer thinks the adjudicator has got it wrong, the employer can begin an arbitration or litigation to have the matter more fully investigated. But in the meantime, while those proceedings are wending their way, the money is in the pocket of the contractor, in the example I've given, but it would apply equally to a subcontractor. And as I say in my paper at paragraph 3.4, the party may litigate if it doesn't like it. At the conclusion of the more thorough process of litigation or arbitration, the decision reached by the judge or arbitrator becomes operative and the adjudicator's decision is superseded. Now, the statute works in this way. It requires every contract to incorporate a payment regime and an adjudication regime which has the necessary characteristics. What happens if a contract does not import those mandatory provisions? The answer is that a thing called the scheme comes into force. If you look at my paragraph 3.5, you can see that the scheme is set out in the Scheme for Construction Contracts, England and Wales Regulations 1998. The Act and the scheme have had slight amendments over the years. I summarised them in my paper, but I do not go through them. Now, the scheme says that adjudication is mandatory. If either party wants an adjudication, they are entitled to have it. But it's not compulsory in this sense. If both parties wish to dispense with adjudication and proceed straight to litigation or arbitration, they are entitled to do so. The scheme sets out very detailed provisions concerning adjudication. And as I say, the scheme applies whenever the construction contract does not comply with the requirements of the Act. Now, I've set out an extract from the scheme in paragraph 3.7 of my paper. That sets out paragraphs 12 to 18 of the scheme. I will run through this very briefly. Paragraph 12 requires the adjudicator to act impartially and so forth. Paragraph 13 gives the adjudicator very wide powers. He can take the initiative, he can request documents, he can question witnesses, he can call for a hearing or make site visits if he regards it as necessary, he can carry out tests and so forth, and he gives directions as to the timetable of the process. Paragraph 14 requires the parties to comply with that procedure, and paragraph 15 sets out the consequences if a party fails to comply with any direction or request from the adjudicator. In those circumstances, the adjudicator can draw inferences from the non-compliance, and he can make a decision on the basis of the material before him. Paragraph 16 provides that the parties may be represented by lawyers or others if they wish during the adjudication. Paragraph 17 requires the adjudicator to consider all the material which is submitted to him, and paragraph 18 is a confidentiality clause. An adjudication is confidential in just the same way that an arbitration is confidential. So paragraph 18 of the scheme completes my quotation. Then the next paragraph you see, paragraph 3.8, is paragraph 3.8 of my paper. And as I say, the scheme goes on to require the adjudicator to deliver his decision within 28 days. The referring party may extend that period to 42 days. Indeed, if everybody agrees, the period can be extended further. In practice, most adjudications under the scheme are completed within 28 days. I myself have done a number of adjudications under the scheme. They were all completed within 28 days. I'm actually doing one now, which began at the end of May, and so I am required to give my decision by very late June. Well, so much for the statutory procedure and the statutory instrument setting out the requirements. How has the adjudication system worked in practice? As I say in paragraph 3.9, it has worked extremely well. The adjudication regime in the UK has been in place for 22 years. It's generally been popular. Employers like it, contractors like it, subcontractors. They get a swift decision from someone with relevant specialist knowledge. If the dispute concerns engineering, the adjudicator will be an engineer. If the dispute concerns measurement and valuation, the adjudicator will be a quantity surveyor. If the dispute is essentially a legal one, the adjudicator will be a lawyer. And the proof of the pudding is in the eating. It normally happens that the parties to a construction dispute will accept the adjudicator's decision. It is rough and ready. It has been reached in a short space of time. without the thorough process of litigation or arbitration. But most people embroiled in construction disputes don't want to spend forever arguing about them. They want to get resolution, and they want to move on. I would say that in about 99% of cases, the parties accept the adjudicator's decision, or perhaps they reach a settlement of their dispute based upon that decision with a few adjustments. Now, as I say in paragraph 3.10, the parties to substantial construction contracts have their own lawyers who are expert in the field, and they often prefer to provide their own tailor-made adjudication regime. That is fine, so long as it complies with the core requirements of the Act. On the other hand, they may simply agree, well, the scheme shall apply. The adjudication that I'm doing at the moment arises out of a contract which simply says the scheme shall apply. Now I come on to the enforcement of adjudication decisions, which is discussed in paragraph 3.11 of my paper. If the adjudication system is going to work well, it is essential that adjudication decisions are obeyed, and if they're not obeyed, that they are rapidly enforced. The Technology and Construction Court in the UK has developed a swift and efficient procedure for enforcing such decisions. The party seeking to enforce issues proceedings and at the same time applies for summary judgment under Part 24 of the Civil Procedure Rules. The court will then bring that application on for hearing in a very short space of time. When I was judge in charge of the court, I always ensured that adjudication enforcement hearings were brought on as soon as possible after the issue of proceedings. And by and large, the courts will simply uphold what the adjudicator decided. The fact that the adjudicator may have got it wrong is not a defence. If one party thinks the adjudicator has got it wrong, then that party can bring litigation or arbitration. So the court doesn't second guess the adjudicator's decision or go into the rights and wrongs of the dispute. The court looks rather at the process. If it's demonstrated that there has been a lack of natural justice, for example, the adjudicator has failed to consider an important point which one party raised, or hasn't given both parties an opportunity to be heard, then the court may refuse to uphold the adjudicator's decision. But in the great majority of cases, the court will uphold the adjudicator's decision, and certainly that was my experience when I was sitting as a TCC judge. And I cite in paragraph 3.11 of my paper a Court of Appeal authority to that effect. May I now say something about international construction contracts? The 1996 Act, to which I have referred, only applies to building projects in the UK. But very often the parties to international construction projects choose to have an adjudication regime, sometimes with a 3-person panel known as a dispute adjudication board. The contract usually provides for a longer period than 28 days for the decision. I have recently completed one such adjudication as chairman of a dispute adjudication board, a DAB, that concerned a substantial infrastructure project in Latin America. The contract allowed us 3 months to produce our decision. There was a 2-day hearing with leading counsel on both sides, and we produced a very long and detailed decision at the end. This was very different from the sort of adjudication process which one would get in a 28-day adjudication in the UK under the Act. Now, section 4 of my paper sets out a summary of adjudication regimes which have been adopted overseas. I set out in paragraph 4.1 the system which has been adopted in New South Wales. As you can see, there's a 1999 Act. It prohibits parties from contracting out. It bans pay when paid clauses, and it introduces an adjudication regime. That adjudication regime is not as wide as the one in the UK. It only covers disputes about interim and final payments. It doesn't cover other and wider disputes as the UK regime does. And I refer in the latter part of that paragraph to various amendments which are in the pipeline. In Australia, other states and territories have followed suit. Queensland, Victoria and South Australia broadly follow the New South Wales model, and I set out the relevant statutes in paragraph 4.2 of my paper. Western Australia and the Northern Territory have legislation which permits a wider range of disputes to be referred to adjudication, such as extension of time claims and claims for damages. So Western Australia and the Northern Territory have a regime which is much more like that prevailing in the UK. Paragraph 4.3 of my paper deals with New Zealand. I set out the relevant act there, and I comment that many of the amendments which were introduced to that act in 2015 follow the amendments made in the UK. Paragraph 4.4 sets out the Malaysian adjudication regime, where the adjudicator has 45 working days for his decision. So although the time periods differ from one jurisdiction to another, they all have the common feature that a decision is obtained in a very short space of time. Paragraph 4.5 sets out the legislation in Singapore and signposts you to a very interesting and recent article reviewing the recent Singaporean case law on adjudication. Then in paragraph 4.6, I summarize the present position. At least 14 overseas jurisdictions have introduced legislation which is based upon the UK's 1996 Act and of course based upon the Latham Report. Under many of the overseas jurisdictions, disputes about the supply of building materials and goods are included in the adjudication regime, although, as you can see, that is excluded in England and Wales. Now, Mr. Chairman, may I suggest that Kazakhstan considers introducing legislation similar to the 1996 Act in the UK. If Kazakhstan does this, it would be introducing legislation similar to all of those jurisdictions which I have summarized in section 4 of my paper. This would bring Kazakhstan into line with other progressive jurisdictions. If, Mr. Chairman, the Kazakhstan government decides to do this, may I suggest one modification? Let the adjudication scheme also apply to mining, oil and gas contracts. Those contracts are excluded from the UK legislation. But the position in Kazakhstan is very different. As I understand it, a large part of your national wealth comes from fossil fuels and from mining. Therefore, if you decide to introduce an adjudication regime, you may well think it a good idea to extend that regime to include mining, oil and gas contracts. Now, Mr. Chairman, may I move on to section 5 of my paper, the wider use of adjudication. Many people have said, well, since adjudication works so well in the construction field, why not apply this to other areas of dispute resolution? One has got to be slightly cautious about this because, of course, construction is a specialist field of work. Construction disputes are a special area of dispute resolution which has its own characteristics. And I don't suggest that techniques which are beneficial in the field of construction dispute resolution can necessarily be transplanted to all areas of contract law. For example, adjudication would not be suitable where a consumer is concerned. Indeed, the UK Act provides that any domestic contract for construction of a dwelling house falls outside the adjudication regime. So one has got to be careful about extending this particular system. What I suggest in paragraph 5.1 of my paper, there's an obvious area in which one might start extending the adjudication system is professional negligence. In the United Kingdom, some professions are already subject to adjudication. Engineers, architects, and quantity surveyors have contracts with their employers, so a dispute between an architect, an engineer, or a quantity surveyor and his employer is already subject to mandatory adjudication. If somebody employs an architect and thinks that they have produced a negligent design which has caused substantial financial loss, they can commence an adjudication against the architect and get an award of damages if they're right. Obviously, if the architect disagrees, the architect can litigate and get the matter put right later. But in the first instance, the adjudicator's decision must be obeyed. Actually, this system is extremely useful for the professions. I have recently dealt with 2 adjudications in which firms of architects were demanding payment of fees which were due to them. They didn't want to wait while their dispute went through lengthy litigation and counterclaims were advanced. They wanted to secure prompt payment of their fees. To the best of my recollection, in at least one case, and possibly both, I decided that the architect was right and I awarded the payment of fees. If the employer disagreed, then of course the employer could commence litigation and have the matter looked at again much more thoroughly. But this adjudication regime is beneficial both for the professions and for the employers in the realm of those professional contracts. So why not extend the adjudication system to other professions? For example, solicitors, accountants, and other professionals. Now, given all the other problems at the present time, it is unrealistic to suggest that the UK government should set about introducing new legislation to extend the ambit of adjudication to professions in general. But that does not prevent such an extension on a voluntary basis. And as I say in paragraph 5.2 of my paper, the Professional Negligence Bar Association of England and Wales has taken this idea forward. The Professional Negligence Bar Association, known as the PNBA, was founded in 1991. Indeed, I was one of the founding members. It's a large body which has amongst its membership most barristers who do professional negligence work or construction work, and the membership now runs into the thousands. The Professional Negligence Bar Association has introduced a voluntary adjudication scheme. This allows any dispute between a professional person or firm on the one hand and its clients on the other hand to be referred to adjudication. Now, unlike in the construction realm, this is not a mandatory scheme, no professional and no client can insist upon a dispute going to adjudication. It's a voluntary scheme. But if both the professional firm and the client wish to have an adjudication, they can do so. And the Professional Negligence Bar Association scheme provides a ready-made format for that process. Now, if you look at paragraph 5.4 of my paper, you will see that I have set out the core provisions of the PNBA scheme. Paragraph 5.4, so on the next page from the one shown on the screen at the moment. Oh no, it's the same page. My pagination is different to yours. Now, this sets out that the adjudicator will decide the dispute on the facts and according to law. So he can decide questions of his own jurisdiction. He can take the initiative in ascertaining the facts or the law. He can call for the production of documents. This is paragraph 1.3 of the scheme on the next page. That's it. He can make an award of damages, or make an award of damages against the professional, or an award of payment of fees to the professional. And he can also deal with the question of his own remuneration. The adjudicator is required to act impartially and to comply with the principles of procedural fairness. So you can see, Mr. Chairman, that these provisions of the PNBA scheme are modelled on the statutory scheme, but they are much more concise. Section 2 of the PNBA scheme deals with the adjudicator's decision. It must be in writing, it must be reasoned, and critically, please look at paragraph 2.3, it will be binding upon the parties until the dispute is finally determined by legal proceedings, by arbitration, if any relevant contract between the parties provides for arbitration, or the parties otherwise agree to arbitration, or by agreement. So, in the first instance, the parties, having signed up to the PNBA adjudication scheme, must abide by the adjudicator's decision. And if they do not, the court will enforce it. But if the parties or one of them wants a more thorough investigation of the matter, then that party can commence an arbitration if there's an arbitration agreement, or otherwise a litigation, or I suppose settlement negotiations. And the final outcome of that process will ultimately prevail. But until any arbitration or litigation is concluded, the decision of the adjudicator will be binding. Now, 2.3 contains an interesting alternative, which is found in the PNBA scheme, but which is not found in the statutory scheme. If you look at the second alternative in square brackets, it provides that the decision of the adjudicator will be binding upon the parties, subject only to paragraph 17 below, and will not be subject to appeal, whether under the Arbitration Act or otherwise. And then one or other alternative has to be deleted. Then if you look at my paragraph 5.5, the adjudicator is required to reach his decision within 56 days, subject to any extension agreed between the parties. So once again, we have a narrow time limit, but not as narrow as the time limit for construction disputes, which is normally 28 days. A slightly longer time period under the PNBA scheme is very sensible, because if you have a dispute between an accountant and his client, or a solicitor and his client, and there are allegations of professional negligence which might affect the firm's reputation, these will take some time to go into and investigate, and so a slightly longer time limit is understandable, but still the parties will get a very rapid resolution of their dispute. Then I set out paragraph 17 of the PNBA scheme in paragraph 5.5 of my paper. I won't read that out to you because my time is running out, but you can see the last part, which is important. the decision of the adjudicator shall be enforceable by proceedings and an application for summary judgment in the courts. So that's just like the construction scheme. Then look at the last sentence. On such application, subject to any challenge on the basis of jurisdiction or procedural unfairness, it will be no defence that the adjudicator erred in fact or law. In other words, the court will not examine whether the adjudicator came to the right answer or the wrong answer. Why won't the court examine that? Because if the adjudicator got it wrong, it is possible to re-litigate or re-arbitrate the matter through conventional proceedings. So there we are, Mr. Chairman. I have summarised the statutory regime for adjudication in the UK. I have demonstrated that one can also have a voluntary scheme, and I have set out the provisions of such a voluntary scheme. Now we come finally to my paragraph 5.6. I understand that the International Arbitration Centre here at the AIFC is considering introducing an adjudication scheme as an alternative means of dispute resolution. This will probably be a voluntary scheme, so it will be just like the scheme introduced by the Professional Negligence Bar Association in England and Wales. This is just an idea at the moment. If this goes forward, it will be for the registrar or for Barbara Doman QC, who is the head of the International Arbitration Centre here, to announce the details of any such scheme in due course. For what it is worth, I would say that the PNBA scheme has worked very well in England and Wales. It has been used voluntarily by the parties to a number of disputes, and if such a scheme is introduced in the AIFC, I have little doubt that it will be popular and that it will add yet further to the wide range of dispute resolution services which this institution, the court and the arbitration centre, offers, with Chris Campbell-Holt as registrar taking the lead in the administration in all areas.